Ready, start. The convict must be given a show cause notice stating the grounds for cancellation, and he must be provided an opportunity to file a reply. Full stop. If this is not read into the statute, the convict will not be in a position to defend the proceedings. Full stop. The power to grant premature release must be exercised in a fair and reasonable manner. Full stop. It affects the convict's liberty guaranteed under Article 21 of the Constitution. Full stop. The requirement of recording reasons either for granting or rejecting the prayer for permanent remission will have to be read into the provisions of Section 432 of the CRPC and Section 473 of the BNSS. Full stop. Principles of natural justice must be read into the provisions of Section 432 of the CRPC. Full stop. In any case, in the case of Bilkis Yaqub Rasool versus Union of India in paragraph 222.8, this court held that reasons for grant or refusal of remission should be clearly delineated in the order. Full stop. The requirement to record reasons exists. Full stop. Brief reasons must be recorded, which are sufficient to enable the convict to understand why his prayer for remission has been rejected. Full stop. This enables him to challenge the order of rejection. Full stop. It follows that the order passed by the appropriate government of either granting or rejecting the prayer for remission must be communicated to the convict. Full stop. If the prayer is refused, while providing a copy of the order to the convict, he must be informed that he has a right to challenge the order. Full stop. A copy of the order rejecting the prayer must be immediately provided to the Secretary of the District Legal Services Authority so that legal aid can be offered to the prisoner to challenge the order. Full stop. The SOP issued by NALSA on the subject of premature release is very exhaustive and needs to be implemented in its true letter and spirit. Full stop. More often than not, we have noticed that the convicts whose prayer for premature release is rejected are not well informed. Full stop. Writ petitions are being filed in this court wherein either the facts are not fully stated, or there is suppression of facts. Full stop. The reason is that most of the convicts are placed in such a position that they find it difficult to give correct information to their advocates. Full stop. Clause 4.3 of the NALSA SOP is of utmost importance and needs strict implementation. Full stop. When the presiding officer's opinion is sought as per subsections within bracket 2 of section 432 of the CRPC and section 473 of the BNSS, the presiding officer must submit his opinion at the earliest, considering the fact that the issue of liberty of the convict is involved. Full stop. We, therefore, record the following conclusions, within bracket A, where there is a policy of the appropriate government laying down guidelines for consideration of the grant of premature release under section 432 of the CRPC are section 473 of the BNSS, it is the obligation of the appropriate government to consider cases of all convicts for grant of premature release as and when they become eligible for consideration in terms of the policy. Full stop. In such a case, it is not necessary for the convict or his relatives to make a specific application for grant of permanent remission. Full stop. When the jail manual or any other departmental instruction issued by the appropriate government contains such policy guidelines, the aforesaid direction will apply. Full stop. Within bracket B, we direct those states and union territories that do not have a policy dealing with the grant of remission in terms of section 432 of the CRPC or section 473 of the BNSS to formulate a policy within 2 months from today. Full stop. Within bracket C, appropriate government has the power to incorporate suitable conditions in an order granting permanent remission. Full stop. Consideration of various factors, which are mentioned in the paragraph 13 above by way of illustration, is necessary before finalizing the conditions. Full stop. The conditions must aim at ensuring that the criminal tendencies, if any, of the convict remain in check and that the convict rehabilitates himself in the society. Full stop. The conditions should not be so oppressive or stringent that the convict is not able to take advantage of the order granting permanent remission. Full stop. The conditions cannot be vague and should be capable of being performed. Full stop.